So there are a number of things that we need to understand in order to really make sure that we're fluent in this idea of jurisdiction for the purposes of the legal considerations of the emerging technologies that we'll be discussing in this course. So Cormier deals with all of these really well in the chapter that you have been asked to read, and so there will be value in you working through that and some of the examples that she gives. I think that will really help consolidate that understanding. But the purpose of these lectures is really to highlight what it is that you should be looking for. So let's look at these concepts: the jurisdiction to adjudicate, the jurisdiction to enforce, the jurisdiction to prescribe, and then the 5 principles of territoriality or of jurisdiction that are really necessary to ensure that a state can exercise its jurisdiction, that is the jurisdiction to adjudicate, enforce, or to prescribe in a particular territory or over particular events or particular persons. So we've already begun to explore this idea of a person, which, at risk of over-egging the pudding, shall we say, we're talking about incorporated entities, so legal personalities that are created as a consequence of the way a statute has operated. So that is the legal personality. The most obvious of those is a company, but it might also be some sort of form of incorporated association or incorporated partnership, a limited liability partnership, that kind of thing. Obviously, this idea of a person comes from the idea of a natural person, and natural people or citizens are subject to the jurisdiction of the nation from which they come, where they hold citizenship, but also when they are in another nation's territory, they may or may not be subject to the jurisdiction of that territory. Now that seems pretty straightforward when we're talking about citizens, but actually already I think those of you who read the materials in the week 0 section of this course will have noticed that actually who a person is a matter of the understanding of the culture and the legal system of the territory claiming that jurisdiction, or whose jurisdiction that person is seeking. It took a very long time for the Australian government to recognise the personhood of the original owners of this country, for example. There are many stateless people in the world at the moment, so people who are without a home or a home state or a place that they can call their citizenship. In some territories, a person's gender or gender identity or sexual preference or religion can impact the way that the state sees their personhood. So it is a complex and really fraught area for us to think about, exacerbated perhaps by the way that people deal with each other, people in the broader sense of both corporations, incorporated personalities, and individuals over the World Wide Web. So let's just narrow into these one by one. So jurisdiction to adjudicate is essentially the power that a nation or a state has to subject people, natural people and legal people, or things, assets, machinery, ways of doing business, natural resources, to its legal system, to its courts, to its decision-making power. It's also the right that nations have to apply the laws that they have made to certain persons and in relation to certain territories within its border. And I'll talk a little bit more about what a territory is subsequently. Jurisdiction to enforce. That is the power to enforce a law. So to require somebody to comply with a law or to punish somebody for not complying with that law. It also includes in it the power that nations have, or courts within that nation have, to investigate particular matters, to detain people subject to a trial or who have been accused of breaching a law, and to collect, obtain, and keep an evidence. It's also the power to convene a trial, and to determine what the process of a trial might be. The third of these is the jurisdiction to prescribe, and that, maybe I should have put that first on the list. That is the power to make laws, whether that is the power to make laws by enacting statutes or regulation, or the power to make laws by providing a court system, in the common law system anyway, that has the power to make judge-made laws. Ultimately, the jurisdiction to prescribe is closely linked to that power to proscribe or to prohibit certain conduct as well. Now, lastly, there are 5 important principles that you need to think about when it comes to working out whether or not a territory has or can demand jurisdiction over a certain type of matter. Some of them are more easy than others. So we'll talk about territoriality as a separate undertaking, and I'll come to that later. And then the next 4 are what are referred to as the extraterritorial principles. So nationality, passive personality, protection, and universality. And I'll come back to all of those in one of the other short lectures for this week. But before we go any further, the other important concept that I really want to bring out in this context is the idea of what do we mean by regulation? What do we mean by making laws? In the early days of the internet, many people just saw the internet as a place for, it's been called, for the recreation of the mind. It was seen as a kind of new beginning, a borderless world, and there was this kind of utopian excitement amongst the geeks among us, that this is a place that could go beyond nationality, and that it wouldn't require regulation. So when we think about regulation, the lawyers will immediately go to, well, what is the law? And the word regulation often refers to a particular type of laws, written down laws. But the word regulate means so much more. It's essentially an action or a process of regulating or being regulated. In other words, of prescribing or requiring a particular type of behavior, a bringing in. Now, I think that that's really interesting to think about, particularly as we move into the reasons why it is so difficult, given the borderless nature of the internet, to work out, should it be regulated? If it should be regulated, how should it be regulated? And who or what has the jurisdiction to regulate it? And that's really the nub of the jurisdiction problem that we're talking about today, and it will really be our focus for this week. Way back in the year 2002, I think the judgment came down, but I think it was written, or the case itself was in 2000, in a case of Bonnier Media and Smith and Kestrel. A Scottish judge, Lord Justice Drummond Young, gave the opinion, or part of the opinion, that is quoted on the slide. So those of you who are listening rather than watching this, you might find it beneficial to have a look at this slide with the heading regulation on it. Essentially, what's important here is he focused on the nature of the internet as being a communication process. So he says, in his opinion, it's not appropriate to regard the internet for legal purposes as a mere static physical entity. So it's more than just a group of computers that contain information that are physically linked together. The internet, he said, should rather be viewed as a process of communication, in essence, a system of communication that allows verbal or graphic messages to be set up on one computer, could be anywhere in the world, and then sent to other computers, which likewise might be anywhere else in the world. He said, what is peculiar about the internet is that the message will not be conveyed unless initiative is taken by the operator of the second, the recipient computer. Even so, it's essential to bear in mind that there will be no message at all unless the operator of the first computer, the sending computer, sets up the necessary website. Moreover, when a website is set up, it's self-evident that the intention is that other people should be able to access it via the internet. So a person who creates a website is linking themselves to a process of communication with the obvious intention that communication should take place by way of that process. So when we're thinking about where things happen, it happens at where the first computer is situated, but also where subsequent recipients of those messages are located as well. But back to thinking about this idea of regulating the internet or cyberspace, the QR code that is on the slide there will take you to a declaration of the independence of cyberspace that was made by John Perry Barlow back in February 1996. I won't read it all out to you, but it's really quite a dramatic piece of language, kind of mirroring the Declaration of Independence from the US in some ways. It opens with, "We are creating a world that all may enter without privilege or prejudice accorded by race, economic power, military force, or station of birth. We are creating a world where anyone, anywhere may express their beliefs, no matter how singular, without fear of being coerced into silence or conformity." It's addressed to the nations of the world, by the way, and it reads, "Your legal concepts," so otherwise big formal nations, "your legal concepts of property, expression, identity, movement, and context will not apply to us. They are all based on matter, and there is no matter here in cyberspace." It goes on to say, "Your increasingly obsolete information industries would perpetuate themselves by proposing laws in America and elsewhere that claim to own speech itself. These laws would declare ideas to be another industrial product, no more noble than pig iron. In our world, the internet world, cyberspace, whatever the human mind may create can be reproduced and distributed infinitely at no cost. The global conveyance of thought no longer requires your factories to accomplish emotional stuff, the stuff of revolution." But could it actually be like that? Is there a possibility of a brave new world? Now, some of you might be pop culture fans. You might have heard of the musical Avenue Q. I think if you haven't, it's well and truly worth looking for on YouTube. It's a kind of grown-up parody of the Muppets. For those of you who are easily offended, maybe don't look it up. But it has a brilliant song sung by a puppet, which is "The internet is for porn." I think there is no doubt by the 90s that the real advances that we saw in the development of the internet were largely driven by the porn industry and the gambling industry. Many of the innovations that have become ubiquitous on the internet today were built initially by those industries trying to sell their wares. Of course, they weren't the only ones. But by the late 1990s, we saw that there was a real progression from this idea of a social communication network through to an internet that was largely commercial and transaction-based. A range of issues arose, including how contracts are formed across borders and how are they enforced over the internet. How do we recognize and protect intellectual property rights? Should we be recognising and protecting intellectual property rights. How do we regulate content? How do we protect children, protect vulnerable people, given the number of scams that have been initiated over the internet? And as I said before, the internet is for porn and gambling. How do we maintain or protect privacy? What does that mean in an internet and a connected world? And how do we protect people's security? All of these questions became more and more prevalent by the end of the 90s. So much so that in 1997, then President Bill Clinton released a framework for global electronic commerce. This was largely endorsed by the Australian government at the time, and the Australian government reflected these principles by embarking on a co-regulatory regime in the areas of content regulation and privacy in particular, leading to what were then the Broadcasting Services Online Services Amendment Act in 1999 and the Privacy Amendment or the Private Sector Act 2000, both Commonwealth legislation. The principles for the Clinton framework are on the slide. The QR code will take you to the entirety of that slide for those of you who are interested in it. No need to have a look, but it is interesting reading. Historical, absolutely, more than around 25 years ago now, 26 years ago now. I think the things that really distinguish this is that among these 5 frameworks is this idea that the private sector should lead when it comes to determining how the internet would be governed, and that the industry itself should be self-regulating. And this leads us to probably the most famous academic in this space. The gentleman whose picture you can see on the slide here is Lawrence Lessig. There's a number of really interesting documentaries. Again, for those of you, not necessary, but if you are interested in this stuff, I can't remember the name of it off the top of my head, but the Internet's Own Boy or something like that. Lessig stars in that particular documentary. It was fairly recently available on Netflix, and a riveting story about the early days of the internet and the ways that it impacted particularly people who really found their community in that space. Lessig, as a legal philosopher and a jurisprudential scholar, basically identified 4 modalities of regulation. There are customary norms, the market, law, regulation, statute, that kind of what we normally understand as law, and then architecture. And ultimately argued that the architecture of the internet, the code itself, is the most important part of the law of the internet. Now, sorry, there's a big concept to just throw at you. So let me use a different example. So when we're thinking about regulation, often we start with what is the purpose. So let's say we want to stop people from speeding, driving their cars too fast. There are 4 modalities of regulating a person's speed that we could use. Firstly, we could encourage customary norms that mean that people understand that speeding is dangerous, that it feels like the wrong thing to do, it's a bad thing to do. They are reluctant to step out of what is a customary norm. So we might use advertising for that. We might embed it into our culture in some way. Secondly, we could use the market to help us regulate. So we could raise the price of petrol or tax fuel or tax use of the roads in a way that in some way limits the use of vehicles on the road. So it adds to the cost of driving. The market itself will help us regulate the number of cars on the road and help reduce the speeding problem. We can enact laws that mean it's an offence to speed. So there are somewhat market constraints there. If you are caught speeding, then there is a dollar cost associated with that. But there is also a points cost as well. So you've broken the law, and that can go to other elements of the way that you feel about yourself and the ways that you interact with society. And then the fourth way is we can build restraining architecture into the system. So, for example, speed humps or roundabouts, or we could impose engineered limitations on the vehicle to limit its speed in particular spaces. Really interesting idea at the moment when we're thinking about the emergence of autonomous vehicles. This is something that we will come back to a little bit. So just as architecture in the real world could limit what we can do, architecture in the digital world can, and Lessig would argue should, do the same. The QR code on the slide there, again, for those listening in the podcast, you're going to need to have a look at the slides for this one, I suspect. That will take you to the latest version of Lessig's book about code as law. Now, I'm not suggesting that you read all of that by any stretch of the imagination. Cormier deals with Lessig's arguments at a high level in the chapter that you've been asked to read. But for those of you who are interested, you might find it really fascinating, and to think about, what is law? What is the purpose of the law, and when do we need states to impose law, and when can the system itself impose law? So basically, we've spoken about jurisdiction and we've spoken about regulation so far. In the next video, I'm going to move on to talk to you about the concept of a state, and we'll talk about sovereignty and territory as well. Issues, concerns, frustrations, questions, comments, compliments, you know where to find me.